There are a number of you who represent companies today who are operating in Europe, and so you've had several months now working under the GDPR, and all of you have undoubtedly begun to consider what it would mean to comply with California's new law, the CCPA. So I have three related questions about these laws. And the first is, if we pursue federal legislation in this space, can you identify one or more provisions from either law that we should emulate? Anybody? Mr. Kelly.
Yes, both the laws apply to all companies uniformly, and I think that's a very positive element of both laws that should be emulated. In addition, I would note that California sets the default as opt-out, and while you may not adopt that particular framework, what it does underscore is there is value in the use of data, and it's recognized by that default setting.
Okay. Nobody else? Then if there are conflicts between the two, are there conflicts, I should say, between the two, between California and GDPR, that we should address in a federal law? Mr. Kelly.
Thank you. I think the concerns on both, they're slightly different but significant. So GDPR, the difficulty and challenge is it's overly prescriptive and extremely burdensome. And while the results are early, you see websites have gone dark, hundreds of websites have gone dark. Smaller companies have exited Europe or appear to exit Europe, startup companies, and it looks like it's actually strengthening the large incumbent platforms in Europe. And on top of that, it may, because of the limits on data sets, hurt innovation in things like blockchain and artificial intelligence. California has a number of concerns raised. One, and probably the most significant, is it's a single state. And if other states follow suit, we'll be facing a patchwork of rules and fragmentation that will be just unworkable both for consumers as well as mobile companies and internet companies. And then we do have some concerns. California has a non-discrimination obligation that sounds good in statement. It's ambiguous. It may deny consumers the ability to receive benefits from consumers for sharing their data. And this could affect things as commonplace as your grocery loyalty card program, where you get a benefit for sharing information with your grocery store on your purchases. We're also worried about the notice and consent process because it tends to be serial, it's complex, and it may end up restricting data far more than anyone else anticipated. So what we're urging is a comprehensive federal law that looks at both of these laws, learns from them, but does better than them.
Does your company or any of your companies plan to seek any revisions to the California law before it takes effect?
Yes, AT&T will seek revisions to the law. We are concerned about the non-discrimination obligation, as I say, notice and consent. Right. We're also looking at implementation periods. They're very tight. There are some other things very particular to the law that we are going to work with the legislature and the state AG who's doing the rulemaking on.
So you mentioned in your one of your answers there the issue of GDPR specific requirements for handling, retention, deletion of data. I'd say you mentioned it in your answer, but that's something that I understand is an issue. So do you think that those types of requirements are going to make it harder for companies to launch? It can prevent barriers to entry. You mentioned in your response that you're already seeing the incumbents benefiting from this, but is it going to be harder to get startups launching and at least cause them to avoid doing business in the EU?
Yeah, no, I think there's a host of burdens associated with the GDPR that perhaps if it existed at the time the companies at this table started, we wouldn't be here. None of them would be here. In terms of the rights to access, deletion, portability, we support the concepts, but we need to be mindful. There are cybersecurity concerns, there's fraud and authentication concerns, there are cost concerns in terms of deploying the systems and the time that'll need to be taken to do that. And on portability in particular, we have to make a judgment about whether we'll enhance competition and help smaller companies or actually embed the incumbents where they are. So I think those are a number of questions raised by the GDPR that need to be addressed.
Anybody else want to talk about compliance costs under GDPR to date and whether you think those raise barriers that prevent barriers to entry for startups? Or
Senator, on Google's side, we certainly recognize that the compliance obligations under the GDPR have been a tremendous challenge for us. We took them very seriously. We are confident in our compliance posture, but we encourage the committee in contemplating future legislation when you are looking at the GDPR as a reference point to carefully consider this point, because organizations like Google are clearly better positioned to absorb the kinds of compliance costs that a rigorous regulatory regime like that required under the GDPR could create for small and medium-sized businesses.
And Mr. Chairman, if I might add, we're a domestic-based ISP, and so our services are focused here in the U.S., so we are not subject to GDPR. So we're watching it and recognize that it's a model that folks are looking at, but we don't know what it will take for us to implement it, what the costs will be, what new systems we may have to build, and there will be a number of other companies across the U.S. that will have those same concerns. So as you're looking at the GDPR, I think it's important for this committee, and we're glad that you're having this hearing today to start the conversation, to put its own stamp on what the U.S. framework should be for privacy protections to ensure that companies can comply, that we have enough time to comply. So we certainly see the common principles emerging in terms of control, transparency, and equal treatment of data across the sector. But I would just say that there are certain things that we just don't even know what it will mean to implement here in the U.S.
Thanks. Mr.
Yes, I think with the exception of here, most of the other companies at this table have gone through the process and are probably of the size well able to take on the implementation work necessary to implement the GDPR. I'd like to point out, we have an app store with 6 million developers in the U.S. Many of those are small and medium-sized businesses, and so I think it's very important in looking at legislation to look at those small and medium businesses and what the burden will be on